Good morning, everyone, and welcome to our roundtable discussion today on the subject of music law. In 2012, I set up a master's degree programme along with Les Gillon in music industry management at UCLan with a number of key industry people, including Peter Hook from Joy Division and New Order. Congratulations, Peter, on your nomination for an induction into the Rock and Roll Hall of Fame. Also hardwired into the course is Aaron Meller, who runs the largest privately held music venue company in the UK. But consequently, as a result of us working on this course, we constantly review the needs of future music industry professionals. So law is particularly important as it underpins the music industry. We draw on different types of law to enable practice. Those include intellectual property law, contract law, and others. But music law, for one reason or another, we discovered that there was relatively little written about this complicated aspect of the industry. And in itself, it is a developing entity, a developing field. So we set out on a mission to help develop our understanding and even impact on practice of this vital part of the industry. And in 2019, we ran a conference at the University of Central Lancashire, which brought together academics and experts from industry and some who wear both hats. One of those people was Anne Harrison, who, as well as being a leading British lawyer, is author of an important book called Music the Business, which is now in its 8th edition. Anne and myself, along with the brilliance of 13 other contributors, including the 3 people you see with me here today, produced an excellent book called The Present and Future of Music Law, which is officially available in the very affordable paperback format tomorrow from Bloomsbury Academic and lots of other good bookshops. Before we get started, I'd like to just quickly thank Glenn Woodruff and Lucilla Green, who's Director of Rights Data Operations at Warner Music Group, for their contributions to the project, because we probably wouldn't be sitting here were it not for them as well. Today, we're going to take a look at current developments in the music industry, including 2 of the subjects covered in chapters in the book, which are very topical. They include the acoustic trademark, which Katarzyna will be telling us more about, and how we reduce the impact of music on the environment, and the situation with law as it stands. But all of the chapters in the book are very important and valuable and uncover important aspects of the music industry. So I'm going to start today's proceedings by asking our panelists, our distinguished panelists today, to introduce themselves and tell us a little bit about what they do and their relationship with the music industry. Can we start with Katarzyna, please?
Good evening, everyone. Hello from Poland, I should say, because I'm here in Poland. Well, as you already know, my name is Katarzyna Krupa-Lipinska, and I'm both practicing lawyer. I'm running my own company, and I'm advising a lot of clients also in cases of trademarks. And on the other hand, I'm also an academic, and I'm teaching at 2 universities. One university is University in Toruń, and the other university is Łazarski University in Warsaw, where I'm teaching IP law. So basically, I do both things. I'm practicing lawyer on one hand, and on the other hand, I'm an academic teaching IP law to my students. So that's according to my introduction.
Thank you, Katarzyna. Thank you. Teresa.
Yes, hi. My name is Teresa Moore. I'm director at a Greener Festival. I'm also co-founder of Green Events and Innovations, the foremost sustainability conference for the music and events industry. I came from academia and went back into industry a few years ago now, My personal interests have always been in the environment, and one of the things that I noticed since being back in industry really is that practice, certainly in terms of the environmental impact of live music, practice has been leading legislation. So it prompted me to have a closer look at the whole issue and just see, whether there are any signs that legislation might catch up with practice, or what, where we're going in the future. Greener Festival, we were founded in 2006. In various capacities, I've worked with them since then, before officially joining as a director. And our mission has always been to help the industry reduce its environmental impact.
Thanks, Teresa. Jules, could you tell us a little bit about yourself? I'd like to sort of acknowledge and recognise you as somebody who's played a significant role in shaping our industry, before you talk a little bit about the things that you've done and you do.
Well, shaping our industry is very bold of you. I wouldn't go so far. I think I've had a significant impact in shaping the electronic music industry, which is a significant player in terms of market share and financially, but the music industry as a whole, I wouldn't take credit for. So I'm Jules O'Riordan by day in my lawyer capacity. My sort of historical artistic moniker is Judge Jules, although as a DJ and music maker, radio presenter and various other things, I am not a judge, I should hasten to add. Whenever I'm stepping into my lawyer shoes, I think it's important to separate myself from those two roles. I've spent 30 plus years as an artist, dare I say, at the highest level. I've run a couple of different imprints in senior A&R role for Universal music entities. I was a presenter on BBC Radio 1 for 15 years. I promoted very large scale events for a long period of time, particularly in Ibiza. And I've made lots of records, as well as having done probably 5,000 DJ gigs in my career. So that's me, the artist. And obviously that I'm actually, dare I say it, probably, I think it's reasonable to say actually, the world's only active artist and specialist music lawyer. I've been a lawyer, I'm now in my 11th year as a lawyer. I'm a partner at Sound Advice here in Talyard, which is probably the biggest enclave of music-related businesses in the world, actually. It lives and breathes music amongst about 200 different businesses, and it's nice to be the only law firm here in amongst the slightly less staid, crazy creatives. And I come at this from, initially as a lawyer, I came at it from the angle of being an artist, but as one's practice grows, I represent all manner of different entities and individuals from both sides of the equation within the music business. So whilst I can represent artists, I also represent managers, clearly not in the same transaction. I represent record labels. I mean, pretty much if it lives and breathes music, I've got a client that does something in relation to it by this stage of the game. In terms of what to talk about today, I guess having seen the slightly different angles that my sort of compatriots on the panel today will be talking about, in particular, one would talk about NFTs, but there are other developments that are more evolutionary rather than revolutionary within our industry that I can also talk about.
That's great, Jules. Thank you very much. It's interesting. You opened so many doors just in your introduction, really, that one of the things we talk about in the book is perspectives. And you understand really all perspectives of the industry. You can see it from all sides, which is quite a rare thing, I think, really. But of course, it makes you a brilliant choice of lawyer for many creators, music creators, artists.
Interestingly, and arguably not very relevant to the legal aspect, I think a psychological understanding of the common thread that runs through all creatives, having got that slight madness in myself, is very beneficial in terms of, if you like, bedside manner and understanding of the people one is dealing with.
Yeah, but I think, you know, that is, it kind of is related to law and how it interacts with the industry, isn't it, really? You know, one of the things that is an important decision for artists is who they have on their team. So yeah, it's there's lots of things that talk to each other in this sort of multifaceted industry. But Jules, can I ask you to? It would be really great if you could just provide us some context as to what is happening and what in the music industry and music law. What are you seeing and doing in your practice with sound advice?
I mean, I think it's always one really. When I became a partner and somebody involved in the process of recruiting lawyers, as opposed to being a growing, jobbing lawyer, you instantly start to realise the key attributes to be a music lawyer. And actually, it's impossible. I'm sure there are very dry academic areas of law where one can completely view the sort of black letter statute and kind of case law based aspect of law in isolation, away from the commercial reality of the way that laws apply. But in music law, really it is, and I'm slightly dumbing it down when I say it, but it's a useful expression. It's 51% commercial awareness and 49% law. In reality, I think it's more than 51%. And therefore, it's the commercial application of pre-existing law that is the more relevant developments, or that has been the more relevant developments over the past few years, both in the sort of post-pandemic era and more generally.
So you're saying it's industry understanding that informs the application of law?
Absolutely,
yeah. Yes.
I mean, there are many examples I could give. I mean, I could do a whole subsection on NFTs, which I would suggest I do a little bit later, because that's it's its own bubble. But for example, we've seen the evolution of streaming services, and it's anybody that's been involved in or has studied the music business over the past couple of decades will have witnessed that sort of it's almost like a sort of a rom-com in terms of sort of happy moments and sad moments. And the sad moments came in the early noughties with the onset of file sharing, Napster et al. And very slowly and eventually came the Spotify model. We won't go into too much detail about how the royalties are shared. I think you either know it and you're interested, or you don't. But the reality, it's the all-you-can-eat model, subscription-based model, and the corollary of that has been the death in most genres anyway of the album, because the album only really, even with a digital download type of exploitation, the album still existed within its sort of pre-packaged form. You had the artwork, you had the track listing, it came in the order that it was provided, and of course you could play whichever tracks you wanted. With the streaming, streaming is a much more immediate way of consuming music, very beneficial in my case, having sort of teenage kids, watching how they've consumed it, and the mode of consumption has changed completely, and the deals have followed through from that. So it's all about the track. It's all about dipping into your favorite tracks. Of course, artists, the branding, the way that the artistic sort of entity and image is marketed is important to inspire interest in given tracks. And the result of that is that many more deals are about multi singles, as opposed to record labels buying into an album by an artist. Yeah. And that brings into play a lot of, to a certain extent, it's slightly, I'm slightly spinning it out by trying to tie the legal element of that into things. But of course, I guess the result of that is potentially rather longer deals if you've got multi-singles deals, which come out over a lengthy period of time, as compared to the shorter, snappier period around the release of one album. I guess the legal themes in relation to that are restraint of trade, the extent to which those sort of longer deals on an exclusive basis are in the artist's interest, and therefore it's all the more important for them to have legal advice. I know that the position in different countries varies. It's not a copyright issue, it's an issue of sort of handcuffs, if you like. Sometimes I like to, when explaining what I do, both to students, because I lecture at both sort of higher and further education institutions, but also go to the Brit School very regularly, which is one of the it's really maybe the #1 fame school, for want of a better description, in the world. And I try and sort of dumb down what I do to make it a little bit sexier and more interesting. And it's basically about three things. It's about following the rights, following the money, and following the handcuffs. And the handcuffs bit is is what is particularly relevant, where potentially longer deals, because people only want to buy into singles, but record companies still want the end game. If they're investing in the short term, they want to know that they're going to benefit if the artist blossoms. And in the past, that blossom took the shape of an album. Now, because people aren't as interested in albums, in certain genres maybe, but in many genres, many of the more mainstream genres, they're not. The record label feels that they need to benefit with a multitude of singles, be in it for the long term. And that's where one needs to look at the handcuffs. And I'm slightly loath to use that expression in this slightly more academic environment, but that's the reality of it.
Yeah, it's for industry to have again, it's a perspective thing, isn't it? Industry should have the opportunity to recoup on investments if they are investing. And therefore, term is an important part of deals. Artists, they would naturally want to have more freedom, and somewhere in the middle, lawyers will advise, what is a good thing to do for their clients, won't they?
Well, they will do. I mean, unfortunately, it's selling an artist is no different from selling a widget. You can sell lead widgets or platinum widgets, or you can sell in-demand widgets or non-in-demand widgets, and supply and demand will ultimately determine the extent to which the artist has more control over saying yes or no to otherwise unpalatable deal terms. Yeah,
depends on how proven they are, I guess, at that time, or the belief in
proven is one thing. I think it's an absolute given. If you want to sign with even a sort of mid-level label, depending on who one believes, there are somewhere between 50 and 100,000 releases on Spotify globally every day, and that's the challenge that any artist faces in sticking their head above the parapet. So it's almost a given that if you want to be signed by a sort of medium range through to major label, you've got to have done that self-marketing. You've got to be better than just somebody who can make a great tune. You've got to be an all-rounder. But being able to market yourself and get above the parapet and get noticed is an absolute given. You won't get beyond first base if you don't do that. So in many ways, the sort of one of the best bits of bargaining position one can ever have, and ironically, I'm in the midst of a very similar deal as we speak. Many weeks I am, in fact, is where multiple major labels want to sign the same artist, and that's where many of the principles and if you like the red lines that certain labels might generally apply to a deal begin to evaporate.
Yeah, it's a really interesting point, Jules. Are you seeing the terms lengthening or shortening of deals then? What's happening in
there are two. That's a twofold answer, really. It depends whether you're talking about term, which is generally understood to mean a period of exclusivity during which the artist can't go away and release music elsewhere, or you're talking the rights period, which is i.e. the period during which the record company has exclusive exploitation rights in the particular tracks that are covered by the deal. I'm talking about record deals here, but there are similar principles that apply in music publishing as well. I think in relation to the former, the term, the period of exclusivity, where I've managed to add a lot of value is by getting record labels, in particular in the electronic music sphere, but to a lesser extent in the UK black music area as well, to get record labels to allow artists in the midst of their major label deals to release tracks on independent, smaller labels, because this whole, the conveyor belt of music, this whole culture of releasing singles has moved the conveyor belt significantly faster, meaning that in order to maintain a position in the marketplace, you've got to release so much more stuff. It's almost like battering people over the head subliminally with the artist branding. So that element of deals, it has changed, and I wouldn't take sole credit for doing it, but I've certainly, with my DJ background and understanding of the distinction between below the radar independent sort of underground releases versus the headline major label releases, have managed to secure that for the majority of my clients.
Flexibility, in essence. Your clients are often artists, aren't they?
Yes, correct.
So to get them that flexibility is quite profound in terms of the impact it can have on their careers. But there are restrictions. I mean, it's important to understand there are restrictions there. It's not, they can't be going and releasing on competitor major label imprints. Sure. That wouldn't happen. Just to touch upon your second question, well, the second fork in the road, if you like, which is the rights period duration. I think for the most part, independent label rights periods have remained the same, and they can. I mean, I could give you the promised land short rights period of 5 years, but in reality, rights periods are for independent labels are somewhere between 10 years and perpetuity. And I don't think for independent labels that's changed very much during recent times. With major labels, it tends to be an area of policy. And I don't want to speak out of turn. This is my own theory, I should point out, rather than necessarily it being rooted in fact. But each of the major labels, Warner Music, Sony Music, and Universal, each have their own policy vis-a-vis rights periods. And I've seen a slight improvement over time with regard to Universal, who spent a while only accepting rights periods in perpetuity, which was funny. It seemed to run right up to when they sold a share of the business, which I found very interesting, because obviously as a record label, all you are is your A&R resources and your master rights. That's that's the value in the business. Of course, on a different level, your turnover is relevant, but in terms of the valuation of your business, and I've noticed since they've sold a share of the business, they've become a little bit more flexible and haven't insisted on rights periods in perpetuity. My assumption is the two are linked. It may not be, but I suspect so. Sony have got slightly worse in that they've got one can get a typical sort of 12 to 15 year rights period, but they insist upon an extension to the rights period post expiry of that initial rights period for the payment of an additional advance. Mm-hmm. And Warner are probably the best in that respect, haven't changed very much. One can normally get away with the 12 to 15 year rights period. So there has been a bit of evolution during the last few years. I wouldn't like to sort of watermark it or post-date it with the pandemic. I think it's just been an evolution over the last 3 or 4 years. We saw the fixed streaming campaign, didn't we? You can't help but think that maybe the record labels have experienced more scrutiny as a result of that, and streaming royalties and things are working their way through the system, perhaps. I mean, there's been that they are extremely reluctant to pay a different royalty rate for streaming as compared to other forms of exploitation or other forms of release royalty-based exploitation. But then again, the other forms of exploitation have really fallen to the wayside. People talk about vinyl being a successful format, but the reality is it's still quite niche, and streaming accounts for the vast majority of the income now. There is a sort of philosophical debate, and I'm sort of in two minds about it regarding, of course, record companies used to be in the manufacturing and the distribution business. They were, if you like, speculating on a product, which is the artist's music. They were then manufacturing that product and distributing it. Now they're not doing either of those things now. They are simply a music proliferator, if you like, or a developer of artists. And there is a moral and a business case that they should be paid, because they don't have the expense of manufacturing and distribution
anymore, or certainly significantly less expensive in that regard, that royalties should increase. And that's been part of the argument that was put forward in the recent government inquiry on the subject. There's been total opposition from the majors, it should be pointed out, and royalty rates haven't really increased in any material sense in the streaming era.
Yeah, it's interesting though, isn't it? Because policymakers have become involved there, and it will be interesting to see how things play out if they change at all as a result of the reviews that we've seen in this country.
Yeah, I mean, I think that really the only government would struggle to impose commercial terms on businesses operating in the free market unless there could be some sort of collusion, antitrust type approach. But I'm not sure if that's necessarily a path that it would be easy to go down. Yeah,
for sure. Interestingly, I had a comment from Sander Petit, who's an attorney at Backstage Legal and a DJ, by the way, in Amsterdam. And he's commented, perpetuity also asks for a perpetuate obligation to exploit if there's no active exploitation. So not just uploading it once, then you could dissolve the deal, right? So it's a kind of a question.
Well, that's great in theory, but I think you'd really struggle to get that over the line. And it's more theoretical rather than practical in the modern world, where, as he comments, if you put something up online, you are exploiting it. I mean, there isn't really active catalogue, even in the physical era. There wasn't necessarily active catalogue, proactive marketed catalogue exploitation of catalogue. So to allow an artist to terminate or reduce the rights period on the basis that there wasn't an active marketing of the master continuing would be a tall order. I mean, if he's got away with that, he's an attorney and he's got away with that in some of his
but it's interesting.
Drafting, that's a great achievement, but I don't think you get away with that with a major.
Yeah, certainly
not any major that I've ever dealt with.
There's lots of interesting points here. One of them is kind of online, not predetermined. We've got one lawyer commenting and another lawyer responding, and this is part of the workings of the industry, isn't it? It's how things are worked out, isn't it? How deals are negotiated in real practical terms. Points at
but within the parameters of what I mean. I do a lot of deals. I deal with independents a lot, but because my level of clients, especially in the electronic music world, is very high. It's mainly dealing with major labels, and major labels have red lines that they cannot and will not cross. I mean, you won't. There is probably only a small handful of artists in the world who signing current record deals who'd be on more than a royalty of 30%, for example. Sure. And even 30% is exceptionally rare.
Yeah.
There are simply points beyond which one cannot get any artist and any hot deal.
Yeah, it's something you have to have a lot of power and weight to get a deal like that. Full stop, really, don't you? But Jules, this has been fascinating. I'm mindful we need to hear from our other guests, but before we do, could we touch on NFTs and blockchain, because it's a hot topic, people are interested on it. Can we just open that door briefly, look in?
Of course, yeah. I mean, I think one needs to view NFTs through the prism of pre-existing copyright law, effectively. Sure. It's a different angle. I mean, the first point to make is that since the value of cryptocurrency has I wouldn't say gone down the toilet, but it's become extremely unpredictable and become rather a dangerous proposition. I've noticed the NFTs are slightly dropping off people's lips, or it's not the hot topic that it was, because it's just so concerning from that perspective. I think the most different commercial aspects of NFTs are twofold. One is it's a license. On the one hand, the shop window might appear that you're buying an assignment of rights in something. It is effectively a license because you're limited in what you can do with it. It's a license based around ownership of the digital token rather than the intellectual property that sits behind that token. And that doesn't really change very much from a legal perspective, but it's important to understand it in that context. And the second thing about, I think the interesting commercial aspect of NFTs that makes them different from other exploitations of art in particular is the fact that there's a residual payment on resale, which brings into context the whole concept of exhaustion of rights. In certain intellectual property transactions, there is an exhaustion of rights once you sell that piece of IP, but here you have an ongoing right to a residual payment every time it's resold, albeit that will be the percentage of which will be negotiated at the time you do your deal with the NFT agency or whoever is launching those NFTs. But I think from a practical perspective, notwithstanding what I've just said about it being a more difficult environment because of what's happened to crypto recently, I think a lot of conventional, I have many calls with clients who sort of send me a contract in relation to NFTs, and I think it's better to get back to basics and ask three important questions, which is one, we're talking music artists here, do you have a fan base who are likely to buy NFTs? Because if you're more of a heritage artist with an older demographic who are not as deep into the digital world, then is it right for you? That's point number one. Point number two is, what is the NFT? Are you actually providing something that people want? Because so many times when the sort of emperor's new clothes element of NFT launches began a couple of years ago, there was a period when it was like artists were kind of giving people I'm sorry I say it this like this, but a bit of shit to not sell ultimately. And thirdly, are you dealing with an entity who has a good marketing strategy behind it? Because you, the creative, plus the entity that is marketing your NFT, has got to be good at marketing it. People are not just going to run it. It's like any product. People are not just going to run in the direction of it simply because it exists. You need to spread the word. So there's a lot more commercial considerations, I think, than legal ones, but it's good to touch on both.
Yeah, I think it's great, Jules. Hearing you talk, you can clearly hear your extensive knowledge of the industry and how it works and how it informs your practice on a daily basis when you're dealing with your clients. But that's brilliant, Jules. Please hang around, and it would be good if you're very welcome, and it would be great if you wanted to contribute to the conversations that we're going to have now with Katarzyna and Teresa. I'm just thinking, Katarzyna, should we move on to the acoustic trademark, which I'd actually not heard of an acoustic. I've worked in and around the music industry for many years, and in 2019, I think when you sent a paper saying you'd like to talk about this at the conference, I'd not heard of an acoustic trademark, and I'm not embarrassed to say that, because it's not something that is, it's something that is becoming more and more prominent. I think, we've seen more and more things written about it since you wrote the chapter of this book. And sorry, can I just actually acknowledge that there's a great chapter in the book on blockchain written by Charlotte O'Mara, which Jules obviously was just really scratching the surface of, the NFT blockchain issue. So people should read that as well. But Katarzyna, can you tell us, why do we need to know about acoustic trademarks? Over to you.
Yes, thank you. You've mentioned that you haven't heard about the acoustic trademarks before my application to the conference, and you're not the only one, because usually when I'm this is a sphere of law, I mean, the acoustic trademarks, that actually combines both music law and IP law. And usually from the perspective of IP lawyers, those sound or acoustic trademarks are, not very, not very much, explored. Because this is one type of the trademark not very often applied for, and etc. So it is that the lawyers are not paying much attention to it. But on the other hand, the music law lawyers got a very limited knowledge about it, and sometimes they simply doesn't know that there is something like the acoustic trademark that they may actually tell their clients to register. So I think that this part of the IP law is of the great concern of both the IP lawyers and music law lawyers, Why is it important? Well, from my perspective, is because this is business, and this is not that there are money, relating to it, because you're protecting a right, which is very important right and very strong right, and this is something that is in the register. So all those elements of protecting copyrights and those issues that we have in the copyright law concerning the protection and this, creative elements, which are there, and proving that in the court and discussing that, are not present in here in the trademark law, because then you've got certain right in the register. So you're basically showing what is in the register. Of course, I'm quite making a theory right now, because I know no case concerning acoustic trademark in the court. This is really like a sphere that is just under the development and under the discussion, or the discussion just starts in the doctrine. When I was applying to your conference, I have to say that I knew only, I think, one or two lawyers that actually wrote anything about it. So I was like exploring totally a new thing. Recently, there has been a few judgments of the European Union Court of Justice that draw the attention of the lawyers. So there's more and more written about it, but still, this is not the crucial topic for IP lawyers, I have to say, from their perspective. But on the other hand, I think that this is very prominent for the music law lawyers, or it should be. And why is it so? I mean, not every musical composition can be protected as a trademark, or should be protected as a trademark. Let's be clear in this point, because of course, when you have the whole song and this song is purely for entertaining reasons, then this is not a trademark. But on the other hand, some musical compositions are done for the commercial purposes, like, for example, in the commercials itself, or as a jingles, or in the internet. Right now, the sphere that is really a great place of new things that are coming. And if something is created for the purposes of indicating certain goods or services, some musical composition, that this is something that might be registered as a trademark. And that gives you the right that is, as I said, registered. Of course, in certain countries, you may also get the registry of the copyright law, which is obviously not the necessity but the protection, but still you may register that, like in US, for example. But here, the registry of the trademark is the essence of this right. So that gives you something in your hand that you can show, and you've got it in the registry. So this is some practical benefit, I think, from getting it. And on the other hand, it gives you the monopoly. This monopoly is different than comparing to copyright law, but it gives you a very strong right anyway.
So they basically, it's a trademark, isn't it? So some of the people watching might not know very much about how trademarks work. Some may know loads, but maybe not in the context of the acoustic mark. So could you tell us a little bit about trademark registration and uses?
Yeah, I mean, well, the first thing, which is one of the basics concerning trademark law, but is quite unknown commonly, is that you register trademark for certain goods and services. So it's not that if I'm having a trademark protection, I'm having it for every single good or services in the world, but for the specific goods and services that you have indicated in your application. And then this is your monopoly is restricted to those goods and services that you've got in your register. There is an exception concerning reputable trademarks, but I wouldn't like to go into details with that. So the first thing is that the trademark right is restricted to the goods and services that you've got in the register. And the second point is that specifically concerning a sound trademark is that you have to represented somehow in the register. And in this sphere, for example, European law has changed because before 2015 we've got the element of graphical representation as a necessity for registering sound trademarks. So in case of the musical sounds, that was quite easy, let's say, because we could put the notation in the registry. But in case of non-musical sounds, like, for example, the classical lion roar of the Metro-Goldwyn-Mayer, we have to circumvent it somehow. So it was circumvented by submitting this cloud of the sound, yes, and additionally submitting the recording of this particular sound. Now the law has changed in Europe, and it is allowed to apply simply by filing the MP3 file, and this is this is important from practical point of view because it eases the way of applying. However, the other aspect of it is that in case of this musical sounds that I think that we are here in this meeting the most interested in, is that I think that sometimes it might be more profitable for the client to still apply it for a sound trademark in the musical notation than to file the recording in MP3. Because, for example, if I'm applying the musical notation, I'm not demanded to submit what is the instrument that I'm playing this melody on.
Sure.
And of course, there we have quite broad protection. Yeah. But on the other hand, when I'm submitting the recording, this recording is somehow played, right, on some instrument or sung or whatever, or mumbled, I don't know. And I think that then this registration is restricted to this particular way that it is presented or also interpreted in case of music. So I think that the recording gives you not so broad protection in case of musical sounds than applying in the form of notation. So it's
quite specific, isn't it? It can be, if it's the notation, it can be represented in different, modified, I guess.
Exactly. And it gives you more broad protection. I'm even comparing it sometimes to those registration of word and combined trademark, word and graphical. So when you've got the trademark, like the sole word, then it is protected regardless of the graphic this word is used on. And when you've elements, it is restricted to the graphic of this word. So, when you're applying for the musical sounds in the form of MP3, then you are restricted to the part. I think that you are restricted to the particular way it is presented in this MP3 recording. But on the other hand, when you're applying in the form of notation.
We lost you a little bit there.
Oh, sorry.
Yeah, but no, I think the message came across very clearly. So why is it important to music makers and music industry, the audio the audio trademark? I know it said sound trademark, and that's a different thing. You know, it's a component, isn't it, of the acoustic trademark?
Well, I think that, you know, this is the basic why you are actually protecting a trademark, because it gives you the monopoly over this sign. In this case, it might be musical sound. Oh, sorry. 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 Because it gives you the monopoly over this the sign, in this case the musical sound, for this particular goods and services. So and
it can be renewed as well, can't it? You know, so which
exactly.
is it doesn't have, there's not a finite term of protection, is there?
I mean, there might be an interesting, you know, relation between the copyright rights that are in this part of the music and the trademark right that is given, because you know, those we are having in Poland the dualistic you know, system of copyright protection. So in case of those economic rights, they are you know, getting into the public domain after 70 years after the death of the author, you know, in general.
Yes.
And the trademark right, you can prolong every 10 years for entirety. So so it's indeed the monopolization of this right for a longer period. However, saying that, I have to say that both copyrights and trademark rights relate to slightly I mean, not slightly, they relate to different, they protect different things, you know, and those rights are, you know, done or made for different purposes. So, but
nevertheless, it's, sorry to interrupt, nevertheless, it's relevant to the exploitation, you know, the monetization of, you know, and protection of that to the rights holder. So it's a fascinating subject, and I would encourage people to buy the affordable paperback and really get into and read your chapter, because there's some great examples of case studies and scoring and various other demonstrations where you really cut into this. Katarzyna, before we move on to Teresa, is there anything else? I mean, what you said is great and very clear. Is there anything else you'd like to add?
Apart from that, I advise you to buy the book.
Yeah, excellent. Okay.
And read a little bit more about it, because in the book I've explored the topic much more in detail. Yeah. So I hope that at least some of you get more familiar with that topic and be interested in protecting the acoustic trademarks.
And if you're going to pursue it, consult a lawyer who knows this subject area as well, I guess. Thank you so much, Katarzyna. Teresa, time has just been flying by with such great things. Can we turn to your pearls of wisdom, and can you share with us and expand on the on greener festivals and how they like to work? You've already said that practice is informing policy. Could you tell us a bit more about that and elaborate on that, and maybe tell us about the model that you talk about in your chapter of this book as well, because that is fascinating and incredibly helpful.
So yes, I guess I should almost start at the beginning. One of the things that we in the live sector have been pretty concerned about, obviously, is our environmental impact. And if you do attitudinal surveys with audiences, the results are always that they're concerned too, very concerned. Actually, the problem is that what happens in reality is somewhat different. So, as I said, our aim at A Greener Festival is to help events understand the issues involved in the environmental impact of their events and how to actually reduce them. And we've been going through since 2006. I think one of the interesting things for me anyway, and it's in the book chapter, is the lag. And there is a substantial lag between practice and legislation. And I'll give you a good example. In October this year in the UK, we'll be seeing the introduction of legislation to ban certain sorts of essentially serveware. So single-use plastic serveware will be banned from October 23 this year. That has taken a long time for government to do. We know there are huge issues with that sort of plastic that obviously doesn't go away, it stays in the environment. We've seen all the issues about oceans and the plastics in oceans. Notably, it doesn't cover things like the single-use plastic water bottle, which is one of the sort of Blue Planet type highlighted issues. But if we look at what's been going on in practice, and this is not actually just live music, in the hospitality industry as well, single-use plastic serveware has been almost eradicated from most live events, let's say. Yes, there are small pockets of it, but mostly it's gone. And it was gone pretty much well before COVID. So, you know, it's just one small example, I think, of sort of eye off the ball, really, in terms of these really important issues that are affecting our environment. And obviously there are bigger issues about greenhouse gas emissions caused by some of the practices at events as well, that legislation is really behind the curve on. So that's a small example coming up later this year. I recently, actually, and it came out pretty much after I'd written the book chapter, but one of the issues that is confronting the live industry at the moment is a debate, and this has also been going on in the background for years, between if we want to reduce the environmental impact of live events, should we introduce legislation through licensing? And that is quite a debate. Now, one of the things about, for example, music festivals is this ethos of being free, sort of liberal type events, and we can manage our own affairs through, you know, through just the organizer and the effects of the things that we put into practice. The debate that's been going on in the background for quite a long time is, well, given that the impact of events has steadily risen over the years, you're not doing a very good job. So what we need is legislation through event licensing law to really put the onus on the organizer to clean up their act. That's in a nutshell, really. That's not to say I necessarily agree with all of that, but that is the debate that's currently facing the industry. So,
so that would be the process to bring about that change, that it would be introduced through the licensing of events.
Yeah, that's the idea.
As conditions.
Yeah. Every event, in order to stage a live event, you have to have a license, and you have to get that license from the local authority. You know, over 20 years ago, we saw health and safety legislation, particularly to do with crowd management and issues like that, really brought into licensing legislation. Well, the argument since then has been going on that actually, if we need to be serious about environmental impacts, we need to do the same thing and bring it into the licensing legislation. And then, you know, from that, there's a lot of issues that arise about obviously the knowledge behind, you know, you've got to have experts operating the licensing legislation. There's got to be some agreement as to what is achievable, how will that be enforced, what are the penalties, and so on and so forth. So there's quite a lot of debate going on. And in the meantime, the live industry has said, actually, we don't want legislation. We can do this ourselves, and are busy producing a sort of, it's called a green code. So developing a green code of practice, self-regulatory, which would give minimum standards that events should achieve in terms of the amount of impact that they have. So I think it's an interesting debate because it's a sort of, it moves into the realms of political philosophy as well. You know, climate change, our impact, you know, albeit that the live music industry is relatively small in comparison to lots of other industries, but nonetheless we do have an impact. You know, what is the best way to tackle climate change? That's the big issue, isn't it?
Yeah. A lot of people, you know, I mean, many people, most people are concerned about this. It's an incredibly topical issue. And actually, you know, as you're saying, that the industry, you know, so trade associations like Live are looking at these things. Could you tell us a little bit about our infrastructure and the, you know, the people who are affecting this positive change, and actually before policy is made, you know, because it's interesting. I mean, the live industry has had a very tough time in recent times because it got completely shut down, and there's an element of recovery and rebuilding still going on, a significant element going on, you know. So
yeah, so well, it actually, there was a sort of consolidation. If you know, if we look at all the associations and the infrastructure with across the music industry, that's live and recorded, for example, publishing, there's tons and tons of different associations and organizations. But under this one sort of banner, what's happened certainly during COVID is that UK Live, which is this sort of, I guess, the lobbying arm of these associations, brought together a whole range of different people from across the industry to say that actually, you know, from the live perspective, we want to make a change. We want to, and AGF have been part of this, take a more holistic view of the impacts, environmental impacts caused by live music. So, you know, up until then, we've really been looking at different parts of the industry and trying to deal with different segments. So obviously looking at the artist, looking at a festival, looking at a arena gig or a venue gig, and our work, along with many others, has been focused on each of those individual parts. What happened with UK Live was we started to take a much more holistic view of the live industry and said, well, actually, all of these areas are related. They're related through touring, for example, and we need to look at how the impact of each of these affects each other. So, for example, an artist who goes on a tour will tour venues and festivals, usually. So what we should have are principles that that match up. You know, it's great to have a venue or arena with its own green policy, an agenda, but really shouldn't that also be reflected in the artist or the tour or festivals, so that we don't have these different segmented areas, that we do have a holistic view of the industry, and that what one area is doing reflects what's happening right across the industry. So sort of bigger picture thing, that has been a huge step forward, I would say. And obviously COVID gave us the chance, because we weren't doing much else during that time, to really reflect on and think more seriously about how we are going to make change in the live music industry, certainly in terms of its environmental impact.
It is permeating, isn't it? Despite difficult conditions, the industry is leading these changes. Things like green riders and we're seeing all kinds of things, aren't we? Initiatives that are being embraced by industry, but there's definitely a school of thought that it would be better not, that industry leads rather than the law on this.
I think because we have a track record really of leading, I think it, and all the innovation, all the issues that we're now beginning to see through legislation have come out of the industry itself. So it's not as if, the industry has been shoddy in its approach. there's been lots and lots of good examples where the industry has led innovation and change. And as I said earlier, legislation has been trying to catch up. I would just mention the artist green rider because that's where we've overlapped, a little bit into more artist territory. One of the things that we did back in 2018 at AGF was to work with not an individual artist, which is what sort of largely had happened before, but with a management company, so that the roster of artists can have, again, it's more holistic, can have access to, a more comprehensive but consistent set of green rider terms in their contracts. One of the resistance from certainly smaller artists has been that, we don't really have a voice, we need to make some money. We can't start stamping our foot and saying we need this and we need that. We're too small, we just need the gig. So the idea behind it was that choose a management company that has a roster of artists that are both big and small, so that you have those small artists have some weight behind them in terms of, a bigger voice. Sure. So that was one of the things. The other thing you asked me about was something that's a really interesting development, and you're right, I find it fascinating, and I've talked about it in the chapter. And this again is to some extent, excuse me, industry leading, but where we're joining forces with government, not in this country, I would say, but in Holland. The Dutch government. And so one of the policies that came out of EU, and we mention it in UK environmental legislation on waste, is the idea of the circular economy. Now, this has been around, circular economy, for over a decade. It's growing in sort of becoming mainstream. But in the festival world, what's happened is that working with the Dutch government, who ultimately want to create a national circular economy, they've realized that actually, if you want to make an economic change on a macro level, it would probably be a good idea to try it out on a micro level in the first instance, just to see how it works and what the pitfalls are. And of course, music festivals are a perfect micro economy. Given that they have to bring everything in sight. It's like creating a small town, or some cases a small city, with every sort of economic, social aspect involved. So it's called the Green Deal. It was actually signed in 2019. Obviously, COVID stopped it in its tracks, but it's now back. And now we have 43 festivals from across Europe and the UK signed to take part in it. And it's really, each of those events are putting into practice aspects of a circular economy, circularity. And the principle is basically, whatever aspect of impact it is, that there is no such thing as waste anymore. It is all a resource. So we change our thinking. And this is a really interesting development. And I think 2023, because we're now, properly underway post-COVID, should see some very interesting results.
Teresa, this is incredibly interesting, and we've run out of time, unfortunately, but it's very easy for me to say people can read more about this in this book, which I hold up here, now available on paperback. I think probably just to round things off, I'd just like to thank our panelists today, Katarzyna, Jules and Teresa, who do brilliant work and are luminaries in their fields, and to also thank my co-editor of the book, Anne Harrison, and all of the contributors who have just produced amazing work. I would like to list them, but we don't really have the time. But thank you so much to everyone, and thank you to the people who have joined us. A very quick mention to Finlay, who is currently running the Association for Electronic Music, He's pointed out that AI might be a good thing for us to talk about at our next online or real world conference, and I couldn't agree more, really. That's another fascinating topic where music law and the industry intersect. But thank you very much again to our panelists. Thank you for everyone who's helping us to develop our understanding and to disseminate knowledge in this topic. Please, we will be back with more insights from the intersection of the music industry and music law. Thank you for joining us.
Thank you.